Good evening. This is Rahul. We're live here from Houston, Texas. Every Tuesday, we do bring in immigration updates. Emily, what do you have today?
Yeah, today we want to talk about these EB-1A coaching agencies, what to watch out for them, what makes some of them potentially scam agencies, and what to do if you've been tricked by one of these fake agencies and actually filed a case, an EB-1A case, what steps you can take, how can you determine whether you're at risk with those. We also want to talk about day one CPT programs. This topic comes up this time of year as people are ending their OPT time after they did not get selected in the H-1B lottery. So many of them are choosing to continue studies, but they want to keep working. And so they do it with these so-called day one CPT schools. Are they legitimate? Or could they actually destroy your immigration future? We're also going to talk about switching employers after your I-140 is approved. What documents do you need to make sure that you have in your possession before you leave that company? And lastly, B2 stays. If you're traveling frequently on a B2, if you've got family that are coming into the US frequently and staying for very long periods of time, what can trigger red flags at the immigration port of entry and what to worry about there?
Emily, I've seen recently a lot of these agencies coming into, and I've had some consultations with people where I said, look, doesn't look like it's, even if you want to make a plan towards EB-1A, and it's going to take about 3 years for you to do all these things, yet they go to these agencies, they got everything approved, even I-140 approved in 6 months.
Mhm.
And the mostly what they are thinking about is that, okay, at the most, my EB-1A gets denied. That's all the consequences is if anything fails. Is that true? Or would there be, if there is any, if you use the agencies and you did a shortcut and you're not eligible, you filed the applications which you don't belong to and you paid money to get these things, will there be any other negative consequences?
There can be. So besides just getting a denial, let's say they mistakenly approve your case. An I-140 can be revoked if USCIS finds that the approval was in gross error. And so if they go back and look back into these cases, which we know they're doing, they are using AI, they are connecting the dots between petitions that are use these same services again and again and seeing repeated language being used, seeing the same awards being used, seeing the same media publishing being done. So they're figuring it out. And so they can go back and issue a notice of intent to revoke an I-140 petition that was already approved. And what's more is the risk for them issuing a revocation with a finding of fraud or misrepresentation on your part. If that happens, you, number one, lose your priority date. And number two, you may be barred permanently from immigrating. So it's going to cause problems for any future visas that you might be applying for and for a future green card, which obviously you're trying to receive, which is the whole point of this. So if you didn't really write your own publications, they were purchased, you received judging certificates without actually doing any kind of evaluation, you had to pay to become a judge, you had to pay for an award or media placement or citation mentions that weren't really organically created. If this agency is promising you guaranteed results in a short time frame, or you never interacted with any attorneys or were rushed to sign things without understanding the process. Those are all signs that you may have been tricked into this fake EB-1A, and it might create very harsh long-term consequences for you.
When it came to my attention, Emily, is that recently we have some revocations of the I-140 and fraud allegations have been made. There are also recently there are some interviews that people were being called for on the 485 application, though, as you know that 485 people can be called for interview. But I've seen a string of people, like a lot of people getting interviewed in a very short period of time, and all of them are EB-1As, though. Some of them have been interviewed previously, also have been interviewed again on the EB-1A aspect, and that really worried me and wanted to look into some of these consultations. Not that we worked on this in EB-1s. These particular EB-1s that I'm speaking about, yeah, there are some of our clients are also being recalled because they want to test that whether our guys are genuine. Mostly we never used any agencies, so we should be fine. Now, when I looked into a couple of the awards, a couple of the publications that you did, and I looked into, I don't want to name it, but you see the Globee Award that you give, Emily, for the people who perform best, and I normally get that award because I do perform much better. Of course, Stephen and Ryan is beating me up a couple of times. That's okay. But the name of that award starts with that, and then when I looked into it for each category, there are so many awards. I don't know. The website is only for awards, and there's nothing wrong. Oscar is only for awards. I don't see them in doing anything else other than awards. But yeah, this one seems to be only for awards, and there is a particular price sheet that how much money it is for you to get these awards, to be the judge of the work of other people. And I see so many of these people in Indian names there. When I have consultations with the individuals that I got this award from this one because this particular the EB-1 agency that have given me, and then I looked into those things. Looks, this is really fake. You're paying money for it. You will be having a chance of getting the entire I-140 revoked bar forever for paying the money to get these awards, and those things are happening right now. And I also want to strictly warn the people, though, the way I looked into these agencies that are operating, Emily. There are a lot of YouTubers that are doing YouTube. What is an H4? What is it? That seems to be fine to me. I don't see anything wrong in it. But filing an application, preparing an application, that constitutes legal work. They're not supposed to do that. Only a licensed lawyer can to do it. In fact, I was appointed, as you know, by the Supreme Court of Texas to help bring in the people to the justice system, those who are practicing law without any license. Of course, which I did a couple of years where I see all these people practicing law. Now, these people may be actually violating the unauthorized practice of law only. So when I looked into their website to see where these people are, there is no address of these companies. There is nobody that I can even, when if I want to file an unauthorized practice of law complaint against with a bar association, there's nothing there. I mean, I can't even complain because this address is not there. Where am I going to complain? Is it New Jersey, is it New York, or is it which state? It's very strange.
Yeah, and so, what steps should someone take if they have used an agency and they just want to understand what their level of risk is and what if they should take any action with that application? I would say number one, consult with a reputable immigration attorney, not an agency, not a social media influencer. Get a copy of your full case file from the agency. Make sure you have everything that was submitted on your behalf, and then audit that evidence. Identify which documents could be questioned, what was ghost written, what are these kind of unverifiable judging roles, paid press releases, and that sort of thing. Once you do that, document everything, every interaction that you had with this agency. If you were misled or manipulated, keep those communications, keep payment receipts, keep the instructions that they've sent to you. So you can show that these were things that you were tricked into this and it wasn't something that you were doing on your own. And then you may need to consider withdrawing your petition. It's important to do this before USCIS issues a notice of intent to deny or a notice of intent to revoke. A timely retraction of a potentially misrepresentation could be used in your favor in a future filing. That's a clean and honest filing. And then start building your profile legitimately. Write your own content, seek real industry judging, pitch your own stories, focus on real contributions. That's what EB-1A is supposed to be about. And it oftentimes takes 6 to 12 months, not 2 to 3 months. It is not a fast process.
They're telling it's guaranteed. You're going to be in 5 to 6 of those sources. You can qualified. They're also claiming that USCIS will do all the background verification before they approve it. Yes, they do. I don't think so. They do very thoroughly in all cases, though. Then if that's the reason why there is something called intent to revoke. They can revoke the applications that have been filed. When they approved those applications, then at that point of time, they didn't thought that they were fake agencies, fake awards and fake these things. And then later on, they can find, that's a reason why they have this revoke. That means that the immigration did a mistake by approving it. So definitely, if you have not filed the application, I don't want you to file the application. If you have already filed the application, you should consider withdrawing the application. If you already got the I-140 approval, file the 485, you may want to check with an immigration lawyer, not the immigration lawyer these people are suggesting, but an independent immigration lawyer. And I've seen these websites, they have some of these websites, they have some of their lawyers that are handpicked by them. It's very surprising that sees that every work is done by these individuals at the end of the story. That means after the profile is built up for 2 to 3 months or 4 to 5 months, they then take this case to the immigration lawyer and give it to the immigration lawyer. Which actually the way it should have been originated is that it should have been all along started by an immigration lawyer. And then if he needs any help by any agencies, that guy can hire some help like the way we do professors, we do take the help of professors, education evaluators, and a lot of other people. But normally it comes from the immigration lawyer, not directly from the agency, though. So definitely a lot of things need to be checked out on these things. We're going to see a lot of revocations coming in going forward. So please be aware of those things. There's a question that came out here on Heaven is asking that question from YouTube. My EB-1A I-140 has been approved in May of 2023. Worst scenario is I lose the job and go back to India. Can I still file the 485 when the prior date is current in India? First of all, if your I-140 gets revoked, you will not be eligible to file either 485 or consular processing. And the EB-1A revocation, where they are coming in, they are making the allegation that you have committed fraud on immigration by submitting awards or by pay to get awards, those kind of things. So definitely that will be a permanent bar for you, and it may be a lot of problem for you to ever come back into the United States. Anything else, Emily, before we go to the next topic?
I think we can go to the next topic, Day 1 CPT. So this is curricular practical training that starts from the first day of a master's degree program. Therefore, it's referred to as Day 1 CPT. Day 1 CPT is not really a legal term or anything like that. It's just what people call it because it starts the first day of a master's program, and they're often offered by less than reputable universities. Are these programs legitimate? Are they illegal? What's your take on them?
In the last Trump administration, Emily, it was in 2019, I guess. Remember that in about 8 o'clock or 7 o'clock in the morning, I was getting a lot of calls, and I woke you up, or I called you up. We were getting a lot of calls at that point of time saying that the ICE, Immigration Customs Enforcement, now it's very active right now compared to what it was in the previous Trump administration, but definitely we got affected at that point of time. Even the Trump administration came right now, I never got not many calls came from the people who are being arrested by ICE. But in the last Trump administration, if you remember, Emily, Farmington University, the Day 1 CPT University, if anybody wants to look into it, please, it's called Farmington University. They tried to detain and arrest 800 people at one stretch. Of course, they were able to do only 200 people. It took about 3 months, some of those people, to get them out of bail or probably do their voluntary departure where they have to leave to the home country, though. That was a Day 1 CPT University. You want to look into University of Northern New Jersey. You can look into what happened to the students of the University of Northern New Jersey. You can look into the Tri-Valley University. What was the other university? Tri-Valley, there's some other valley university, Emily.
Silicon Valley?
Silicon Valley, yes. Silicon. Initially, when we wrote an article that saying that this Valley University or that Valley University, anyway, the other Valley University sent a notice that, hey, you put the wrong name, and later on turned out that both Valley universities. No, it's Silicon Valley University and Tri Valley University. Both of those things, all these four universities are day one CPT universities. Um, Two of them were sting operations by the immigration authorities. Two of them, I think so. The most of those people who are operating those universities are in jail right now. If I'm not mistaken, maybe some of them may have got out of jail because it's been more than 7 years, 8 years that they got off to jail. Now, if you look into, I mean, you look into all reputable universities, all reputable universities. I don't know how to name University of Dallas, University of California. I don't know all these reputable universities. None of them do give the day one CPTs. There are only very less number of universities that do give in. I know that Campbellsville University, where was that? The other one, Cumberland University. There are some of the universities that do give. We do recommend people not to join these universities. I know you're desperate situation. Just because you're desperate, you can't rob a bank, and that's how serious I feel about it. We do understand a lot of people have joined these universities, though, but there is a danger right now. As you know, that ICE is acting very quickly, then you will be next in list, though. For those people that are these universities, the admission process is like this, Emily. Anybody can get admission. Everybody can get admission. I mean, absolutely everybody, anybody can get admission. When does the class starts? Whenever you want to start it. Typical universities that I've gone to and you have gone to, we both have gone to University of Houston. You did University of Michigan too, is that right? And they start only in August or sometimes in some classes in January and sometimes in June. For these other day one CPTs, anytime you want. There's admission process for the University of Houston that I went to, and you went to University of Houston too. Now, these particular day one CPTs universities, anytime admission, everybody gets admission anytime. And how many days you have to attend the school in a week? 6 days a week. Sorry, I'm sorry. It's not 6 days a week. It's 6 days a year. That was the time when I was going to law school. 6 days a week was the time that I used to go to school, law school. Of course, when I was going to University of Houston, it was only 4 days a week. It was not 5 days, it was only 4 days a week. But anyway, when I did my master's degree. So these kind of universities that have definitely are considered to be fraudulent. They may be affected. So we want people to be careful about it. Now, we did want people, a lot of people filing multiple H-1B applications. Everybody laughed at it as, oh, you can file for 10 different companies. We have clearly said that is wrong. You know what is happening with these people right now? Their H-1B is getting revoked. So be careful on the day one CPT universities. Anything something before we?
Yeah, I mean, what you're risking is being found that you violated your F1 status, denial of an OPT or STEM OPT or a change of status to H-1B. And right now, with the current USCIS policy in the Trump administration, a denial that puts someone out of status and makes them unlawfully present could lead to a notice to appear. You're risking removal proceedings. On top of the fact that, I mean, just think of what ICE has done since January, not only across the board in immigration, but specifically for F1 students. Remember when they terminated 6,000 student SIVIS records in like 2 weeks? I mean, everybody freaked out. People left the country. People filed lawsuits. We got it all worked out. But they did all of that without any kind of advance warning, no notification of any kind of policy change. They just did it. What makes you think they're not going to do something similar for people who are in these day one CPT programs, putting you immediately out of status? Now, guess what? ICE can come pick you up and detain you and put you in removal proceedings. So that's a big risk to take. So avoid these kind of visa mill universities where there's no real campus life, there's no in-person classes, there's no American students there. There's a reason for that. They are not legitimate programs.
And some of these people, when they try to enter into the country, Emily, because they have a stamping with the previous F1 visa with a different organization, and they're trying to enter the country, this officer asked, "Where is your university?" The guy couldn't even name the city where the university was. So that definitely we had some people who got deported who were trying to enter into the university on these universities. Next topic,
All
Emily.
right. Yeah. So if your I-140 has been approved and you're thinking of switching employers, what are the things that you need to know? So first off, is there a time period you should wait after the I-140 approval before you think about changing employers?
Yes, Emily. First is I strongly recommend people to wait until 6 months, 180 days has passed before they can move to a different university, though. The reason is that, sorry, after the I-140 has been passed, wait for 6 months before you move to a different company. The reason is that if you have an I-140 approval with company A and you got an approval within 3 months, you move to a different company, the company A can withdraw the I-140. If they do withdraw it, they can't use this I-140 to get a H-4 EAD. You can't use this I-140 to get the you can't use this I-140 to get the H-4 extension beyond 6 years. So all the strain that you have done may go in waste. Now, only if the company withdraws I-140, though, we strongly recommend for you to wait. Emily, what are the documents that they need to have it later on, though? I know we have told people that if you have an I-140 approved with company A, it's not been withdrawn for six months, you can use this I-140 perpetually, probably for the next 50 years to keep on extending the H-1Bs, because anyway, the prior date in EB-2 and EB-3 are not becoming current. They can extend the H-1B in EB-2 and with company B, company C, company D. What documents are required for company D of company A's to file the H-1B extension? And if those documents are not provided by company A, what are the alternatives?
Yeah, the best thing to get is a copy of your I-140 approval notice. That's the form I-797. That will have your receipt number on it, and it will have your category on it, your priority date, your name, and will confirm that your I-140 has been approved. You never need the original of that, so a copy is fine, soft copy is fine, but you would want to include that with any future H-1B renewal or H-4 EAD. If the company is not willing to provide that, you can still proceed. You can get alternate documents on your own by filling out a Freedom of Information Act request with the Immigration Service, uscis.gov. You can go there. You can basically ask for a copy of your I-140 filing that was done on your behalf. You won't get the actual I-797 approval notice, but what you will get is the I-140 form that was filed on your behalf, and it will have stamps on it from USCIS with handwritten notes confirming that it's been approved, the date it's been approved, and your priority date and category. That is more than sufficient in order for you to be able to get additional H-1B extensions with different employers in the future. It is also helpful if you can get a copy of your PERM labor certification, because that will have all of the details about the job that you were sponsored for. This would be more relevant for if your 485 has already been filed and you were seeking to port to a new employer under AC 21. But it's also relevant to have that PERM approval because you want to make sure in future PERM filings or in future I-140 filings that you are providing consistent information. That PERM approval, when it was filed, it listed specific start date, end date, job title, job duties for all of your former employers. That information should stay consistent between one application to the next. So that's helpful to have. It's not necessarily mandatory if you've kept good records of your dates of employment, but definitely a good idea to get it if you can. Beyond that, a lot of people ask if you need to ask your employer that you're leaving for an experience letter. It's always a good idea to have an employment verification letter if they're willing to provide it. But if in terms of an actual, what we refer to as an experience letter that you would use for an I-140 petition in the future, many people don't need this from the recent employer. And the reason for that is you've already filed and gotten an approved I-140. You already submitted likely experience letters from your previous employers that got you to qualify for that job. So you can reuse those same experience letters again. The only reason you would need an additional experience letter from this most recent employer is if you gained some sort of special skills from that employer that you're now going to use in a future PERM and I-140 filing, or if the new job that you're being sponsored for requires more years of experience and you need to count the experience gained with that last company, then you would want to get experience letters from them. But typically it's best to wait until an attorney tells you, hey, you need to get an experience letter from this company because it needs specific information in it based on whatever the trends are going on at USCIS at the time. So if you get it now and then 5 years from now, you're getting ready to file a new PERM and your attorney says, no, this letter's not good enough, we need more, then you're gonna have to go back and get it again.
Let's go to questions only.
We also haven't talked about B2s yet.
Oh,
So
sorry.
if someone is coming frequently on a B2, staying 6 months every single time, is this a red flag? Should they be worried about coming into the US?
Frequency may not be that more important as much as the amount of time they do spend in every time they come into United States. If somebody is coming like 3, 4 times to United States on a business trip or a family trip, or 5 times a year, I don't see much problem with those people. But if they are coming here and staying for 6 months and they leave the country and then they come back and they stay again for 6 months, it looks like they're staying in United States and visiting their home country. So that is the major problem, though. We have seen some people who have been denied entry when they're trying to come into United States. They have stayed here for 6 months before, and next time they're coming in, they're also staying for 6 months. We strongly recommend people to avoid it. Also, extension of B2 is a very big risky thing. Even though you can file it online, we strongly recommend you do not extend the B2 unless it's a medical reason for the person who is actually is visiting the United States, not for somebody else. If the person has some cancer and then they have going through cancer treatment, definitely I would recommend them to file a B2 extension to stay in this country until the things have been cured. But otherwise, I strongly recommend not to extend it because it will affect. If the B2 extension gets denied, they will not, their visa stamping, which is valid for 10 years, will become invalid. Also, if they do extension, when they go for stamping, it's going to become a problem for them to get a stamping. So staying for long period, definitely not recommend. I would recommend to keep it less than 4 months if possible. And if there is any chance, if people have stayed for more than 4 months and they are trying to come back, at least leave a gap of 6 months before they come back into United States.
Yeah, in these time periods, it's not a bright line test. It's all relative to specific situations and the frequency of travel and how long stays have been so far. But the thing that you have to be aware of is if you're coming into the US, they can always bring you into secondary inspection and look at your phone, look at your bank statements, look at all of your records, and interview you more thoroughly to try to get to what your true intent is and where are you actually living, and that can result in a denial of your being allowed to come into the US. Can also result in that visa being canceled, so your 10-year visa can go away. It can also end up in expedited removal. This is a fast track deportation process where you have no right to go before a judge. You have no right to an attorney. And basically, it's up to CBP to say all the things that you've done wrong, and they cancel your visa. And now you're barred for the next 5 years if you go through expedited removal. That's going to create a future problem for getting any new visa or applying for the green card. So make sure that you are always having ties to your home country, always have the residence abroad, having a temporary intent with the specific travel plans to go home, never overstay, and always be honest during your visa interviews.
Let's go to questions. Question from Abhinav. Abhinav is on H1B. He has a H1B with company A. He has 4 concurrently filed H1Bs. That means he's working for company A as a primary employer. He's also working for 4 different companies. He's 4 different companies on concurrent, which is perfectly legal. We don't see anything wrong in it. Now he moved to J1. He physician J1. That means most probably he got the residency and then he's moved into the physician J1. He's asking the question: does the company has to withdraw the H1Bs, and what are the steps that need to be taken? Abhinav, if you got your J1 status approved in United States, you have moved from H1 to J1, or you went to India, got the J1 stamped and came back on J1, you don't have to worry about the H1Bs, what the company does it. They are supposed to withdraw it, but if they don't withdraw it, it's not going to be any negative thing for you. You can continue going to school, and that will not negatively affect you in any way whatsoever at all.
All right, we've got a number of people bringing up questions about how long you can stay in your home country if you're on an H-1B. Barath says there's so many talks in social media about someone whose entry was denied at the port of entry due to an extended stay outside the US. Another person says, I'm able to see a news article, viral post claims 3 H-1B visa holders were denied entry into the US for staying in India for 60 days. And then another one wants to know what the guidance is on the maximum amount of time staying outside the US. So number one, if you are outside the US, you are not an H-1B worker. You might have an H-1B petition approved. You might have an I-797 approval notice. You might have a visa stamp in your passport, but you're not an H-1B status. You're not in the country. So US immigration laws don't apply to you. You can work in your home country. If you're allowed to work in your home country, you're a citizen of India, you probably can work in India. No problem at all. Now, when people are claiming they were denied entry coming back into the US due to a long stay in India, you're probably not getting the whole truth. Yes, they were probably in India for an extended period of time. What were they doing during that time? Did they lose the job, the US job during that time? My guess is probably. Or maybe the end client that they were supposed to work for didn't want to wait anymore. And so they ended the project. And maybe there was a site visit, or maybe the Kentucky Consular Center reached out, their fraud prevention unit reached out to the end client to say, hey, is this end client letter valid? Did you actually write it? Is this project still ongoing? Are you still expecting this person to come back? And if the end client says, no, that project's over, and then the next day you're traveling into the US on your H-1B visa to go supposedly work for this client, that's a problem. You're going to get denied entry, of course. So I think there's more to those stories. So just staying outside the US for an extended period of time has zero impact on your H-1B. It may have an impact on whether the officer feels it's credible that you still have a US job offer to come back to the US for. So you need to have documentation from your employer, from your US employer, recently dated letter confirming that they still want you back, they still have work available for you, and they're waiting for you to come back. That's the most important thing. Whether you are working remotely for that employer while you're outside the country or not should be irrelevant, because again, H-1B rules don't apply when you're outside the country.
Kalmuri has the same question. Bharat has the same question. Satish has the same question on this one, that the person has been denied entry of 60 days. Guys, if you're in India and if you're working in India, as Emily has pointed out, you're an Indian citizen, you can work in India, absolutely. I am a lawyer in India, and every Indian citizen can work in India, period. I mean, I don't know of any other law that says this country of the citizen cannot work in their own country unless you are under 14 years or age or something. And there are some rules for child labor and other things. But otherwise, Indian citizens or adult citizens can work in India. And is it a problem if you did receive a paycheck in India, and will they deny your entry? Absolutely not. I've never seen that. But I will point out what Emily has said very clearly, that if their concern is when you're staying for a long period of outside the country and coming back, there will be an extra scrutiny. Do you really have a job? Let's say, for example, you've gone to India for 4 months, you're coming back, you're telling that you have a job with the end client. Do you really have a job? That is the main thing that they're going to determine your entry. When people get deported, though, let me tell you one thing, they don't tell you the truth. Now, would they tell us the truth? Absolutely, they do. Now, would they tell us the truth in open media like this? No, they will consult us privately, and that's where we have a consultations. Anybody want to consult? There is a button there that you have to consult. Of course, we charge for the consultation, and we go through all those things. We find completely different stories. So we found this evidence is completely whatever that WhatsApp thing is untrue, not real. Don't get feared about that thing at all.
Ranjit says for a TN visa, is an education qualification mandatory if I have 4 years of experience in the specific area? So the TN has a set list of job categories, and every single job category in that list defines what education is required for that job or experience. So most of them do require a bachelor's degree. Some of them will allow a diploma plus 3 years of experience. So pretty much all of them require education of some sort, except for the management consultant category that you can qualify for with 5 years of experience, not 4. But that's a very tricky category. There's a lot of people that get denied in that category. People use it as a catch-all when their job doesn't fall into any of the other categories or when they don't have the education needed. So it's used a lot, and for a lot of cases that it really shouldn't be used for. So be careful with that particular category, but most TNs do require specific education.
Kunal Jain, does your organization create LLCs for the people on the GCEAD, the EB-1C? No, we don't, but we do give advice on what jobs you can do, what are the activities that we can do. If you form an LLC, how the paycheck should be structured and all those things. But we don't do the LLCs, we only do immigration. So we normally tell people to contact other lawyers that do that, or CPAs, certified public accountants. They take care of that kind of paperwork much better than us, much cheaper than, and we don't do LLCs. Can you be self-employed on EB-1C? If you yes, you can. Technically you can, but we want you to be very cautious when you're self-employed. Are you on the similar role with the same company though? Are you getting paycheck from this LLC regularly? These are the things we want you to consider very strictly though. Now, we normally don't recommend people to go on their own LLCs though. If you don't have an alternative, definitely we recommend people at that point of time to go on self-employment.
Yeswant says, since 2017, I'm on an H-1B visa. So am I considered a resident alien or non-resident alien? It's actually a tax question, not an immigration question. So you need to look at the IRS rules regarding whether you're a resident or non-resident, or work with a CPA or a tax consultant to figure that out.
Question from Deepthi that she has a priority date of 2017. She has moved from H1 to H4. Can she still file the 485 application if the priority date becomes current? Assuming that the employer is cooperative, if you are an H4 visa, even though you are the primary person on the I-140, absolutely you can file for the 485 application. The main key point here is the employer.
SNH says filed EAD based on a pending 485, but USCIS rejected the application saying it was filed on an outdated version. But when I checked, it's the latest form expiring on 9/30/2027. So you're not looking at the expiration date of the form. That's the OMB expiration date. What you need to be looking at is the form addition date. And the current form addition date is 1/20/2025. So definitely nothing in 2027. So that the newest version of the form came out on January 20th. Actually, it came out before that, but it's been required to be used since then. So that is on the bottom of the form, whereas the date you're looking at is at the top of the form.
Question from MS Forever. The person got an EB-2I-140 approval in NIW. The person lost the job. Can they file the 485 application? Technically, they can file it because it's NIW is kind of self-petition thing. I somehow don't recommend doing it though. I somehow recommend wait until you receive the job and then file the 485 application. Because when you go for the interview and then you're filed a 485 application, when you're not employed, you will look very weak in front of the officer to approve the 485 application. So technically you can, but I don't recommend that you do that.
All Football says, how long is it taking for H4 EAD approvals currently? Mine's pending for 3 months. So it kind of depends if it is standalone H4 EAD where you just filed the I-765 by itself because you already have H4 status and the H-1B has already been extended. Those are taking anywhere from 6 to 12 months. 3 of the 4 service centers are taking closer to 12 months. Only 1 is at the 6-month mark based on their posted processing times. If you filed it with an I-539, so you're extending your H-4 or changing status to H-4 with the EAD at the same time, it's more around 3 to 6 months.
Archana has this question. Can a child who's above 18 years, who is an adjustment of status, can he apply for F1 because the parents are planning to move out of the country for 2 years? Yes, but it depends on the person who is 18 years old. Did he actually started using the EAD, or the person is an H4L2? If the person maintaining the non-immigrant status, it's easy to change the status from the non-immigrant status to the F1 here in the United States. Absolutely not a problem. But if they started using the EAD, that means that they let the non-immigrant status go. You cannot change the status in United States from the adjustment of status EAD to the F1. You will have to go outside the country, get the F1 stamping, which may, under the current circumstances of Trump, become very tough job to get it approved, stamped when the adjustment of status is pending, because for F1, it requires that your intention should be only to temporarily stay in the United States. And once you complete your education, you are supposed to move back to your home country, especially when you have an adjustment of status. It becomes tougher in the consulate now. Now, it is a little bit better when you deal with the USCIS here than with the consulate. Your probabilities of approval here probably will be 90% of the time. Your probabilities of approval when you go to your home country to get the F1 stamping, you will have only 20-25% of chance of approval.
Deepti says, I have a priority date of 2017 and just changed status to H4 and H4 EAD. Is it still possible to apply for the I-485? So assuming you're still on the H4 with H4 EAD when your priority date becomes current, yeah, absolutely. You don't have to be the main applicant of an H-1B in order to be the main applicant of a green card. If you have an approved I-140, priority date becomes current, you're maintaining a non-immigrant status. Doesn't matter if it's H-1B or H-4 EAD, you can file the 485 and your family can file with you.
Evan has this question. His EB-1A I-140 has been approved and he's moved back to India. Can he file the 485 application when the date is current? The answer is no, you can't file the 485 application. 485 application is only for those people who are in the United States. You need to do the consular processing. Heaven, I don't know whether when you file this I-140, you were in USA or you were in your home country. So typically in the I-140, we have to specify, would you file the 485 application? Would you do the consular processing? So if you have picked the column of consular, if you have picked the column of 485, you need to convert that into consular processing. For that, the form is called I-824. I strongly recommend if anybody has any issues where they don't think so that they're going to adjust the status in USA, please use this form called I-824, because even if a person files for the consular processing, they can still file the adjustment of status. But if the person does the adjustment of status in I-140 and they want to convert into consular processing, that may take 27 months in some of the service centers to get that one approved. So definitely, if you have doubt that you are going to stay in your home country, file the I-824 saying that send my approval to the consulate because I'm going to get the green card there. Do it immediately. If you have an EB-1A approved, you're outside the country, file an I-824 ASAP.
Deb says, I'm a Canadian citizen born in India. Is it a good idea to move to H-1B from L-1A if I have an April 2024 priority date, I-140 approved? So I'm assuming that's in the EB-1C category. It is a good idea because the EB-1C category is backlogged for country of birth, India. It's possible you might run out of L-1A time. You only have a 7-year limit. It's not like an H-1B where you can keep extending the L-1A beyond the 7-year limit based on your approved I-140. Only the H-1B allows that. So for a lot of people who are in the backlog countries that are on L-1A, we would try to get them over to H-1B so that they can keep extending beyond the 6-year limit of H-1B based on the approved I-140 in case it takes a while for the priority date to become current and you file the 485 and get an EAD.
Rashidar is lucky enough to get a civil engineering job in Ohio Department of Transportation. Do the state government sponsor H-1B cap exempt? Yes, some of the organizations may be cap exempt. For the cap exempt, you need to understand one thing, that it must not only be a non-profit organization, it must be a higher education institution, which Ohio Department of Transportation is not. But there are, under some limited conditions, they may have some affiliation with the higher education institution, which need to be investigated into. But I'll tell you one thing, Shashikar, though, if you possibly can get a private job, get a private job. Because these agencies, to deal with them, oh, believe me, we used to represent a particular state in southern part of United States. Oh my goodness, it was so bureaucratic. And because the fee has to be paid by the employee cannot pay the fees. And it becomes so burdensome, and that employee was so nice, the 2 or 3 employees, they were so nice to us, but we were bleeding the money because it's so much to do and they have to get to the approvals, and every time it becomes very tough. If you can avoid that, avoid that. Department of Transportation will not automatically qualify for the cap exempt. So definitely the first thing you have to try is go for the cap. If you are an F1 and if you have a time until October of 2026, you should go for the cap. Don't go for cap exempt. And most of these organizations may not be eligible for cap exempt.
Sandy says, my wife was selected in this year's H-1B lottery. I plan to preserve her H-1B time for future after the approval and have her continue working on her H-4 EAD. What are our options? Yeah, it's not a bad idea to take advantage of the fact that she was actually selected in the lottery and get that approval, get that cap number. The only way to make sure that you are counted in the cap is to get the change of status to H-1B approved and let it actually take effect on October 1st. Then on October 2nd, potentially, she could take a trip to Mexico, have a margarita, come back on H-4. Now she's back on H-4. She can use her valid EAD that's not expired. And now she's got that H-1B in her back pocket, and she has 5 years and 364 days available that she can recapture anytime in the future. Does not have to be within the next 3 years, does not have to be with the same company. Very good idea.
Question from Sidhu Reddy on EB-1A adjustment of status PLC. Do you have to maintain the continuous job? Absolutely. I strongly recommend that you maintain the continuous job if you are the primary applicant. If there is a gap, though, it may create a problem. There are exceptions. You can hire a lawyer, you can make an argument. I will try to avoid if you possibly can. So there are ways around it, but I would recommend that if you can maintain the job, that will be the best option that you can do.
Rashna says, what happens to a pending PERM when a person gets laid off? Nothing automatically happens. The employer could choose to withdraw the pending PERM since they don't need it anymore, or they can let it process and get approved and then just not file the I-140 after 6 months. The PERM then expires and the process is over.
Sumit Singh has this question from YouTube. He's asking the question that if the employer is not willing to do premium processing, can he do the premium processing? You can pay for it, but the employer still need to approve. Premium processing can be paid either by the employer or employee. But if the employer says you are not allowed to file it, you are not allowed to pay for it, then you can't. If the employer says that I won't pay, you can pay for it and get it done, you can.
Geary says, can an L2 work on U.S. payroll for a few weeks from abroad when visiting abroad? Well, remember, if you are outside the U.S., you're not in any U.S. immigration status. You are not an L2. If you're in your home country and your home country allows you to work, absolutely, you can work. Could you be on U.S. payroll? Yeah, that's up to the company if they're willing to do that, or if they're going to transfer you to a foreign payroll, if they're going to make you an independent contractor. There's no really restrictions on that, because you're not in L2 status.
The question size, H4, H4 EAD extension were being filed together 4 months ago, not approved yet. Can she travel outside the country for automatic renewal of the EAD? You're not going for automatic renewal of EAD, but of course, if it's an H4 and H4 EAD extension, if the H4 is extended though, and EAD extension has been filed before it expires, yes, there is a possibility for them to get the H4 extension. So first question is, when is your wife's H4 expiring? Assuming that your wife's H4 has already expired, then you don't have the automatic revalidation. She can't go outside the country and come back. She has to go for H4 stamping and come back. Let's assume that on July 20th, her H4 is expiring. And now you got already H1B extended until July 2028. That would be appropriate time for her to leave the country and come back before July 20th and show your H1B approval. 95% of the time, they do give the H4 approval until 2028. Now, since the H4 EAD is getting expired in July 20th of 2025, and she has already filed the extension before July 20th. Once she comes back into the country, she has up to 540 days to get the EAD approval. Until that period of time, she can continue working. Yes, that would be a good plan under these circumstances.
Mohammed says, my employer just applied for the prevailing wage determination last month. How much more time is required to get to the I-140 approval? You've got a long way to go, 18 to 24 months. It's going to take 5 to 6 months to get the prevailing wage determination back. Then your employer may take up to 6 months to complete the recruitment steps before filing the labor certification. Once the labor certification is filed, it's taking over a year to get that. So again, this is assuming this is a PERM based. There are some I-140s that you can file directly with a prevailing wage determination, like Schedule A cases. So not sure if that is your situation. I'm assuming PERM.
People are having questions with regard to what airport is good, what airport is not good. Now, we are not war experts, guys, so we're not going to give you anything about how the war in Iraq and Iran and all those things are going on. We are only going to give you a description about the immigration aspects. That's all. Number one to avoid is Chicago. Number two is Abu Dhabi. These two things is we strongly recommend to avoid. Although recently, a little bit to an extent of Boston is also coming on the list. Atlanta, it's a very big airport. A lot of people travel there. We definitely want to be a little bit cautious with Atlanta when you're traveling. But otherwise, we don't notice any other things. And if we do, we will keep on updating those things.
I'll add Toronto to the list for people who are applying for a TN or L1 Canadians.
That's after
Pearson.
the Trump administration came in. So my question is, if Toronto is like 50% of the entire immigration from Canada, is right? And that's very
think
tough
most people avoid Toronto when they can. I do anyways.
What do you consider Rainbow Bridge compared to Toronto? I don't like the Rainbow Bridge. I would prefer Toronto, but yeah, you may have getting more consultations on that particular front.
Yeah, I'm just not a fan of Pearson.
Okay.
Vamsi says H-1B cap gap extended the OPT to April 1st, 2026. If my H-1B gets denied in this, then the extended STEM OPT gets canceled, but will I still be eligible for the 60-day grace period from the H-1B denial date? Maybe, assuming that the denial of the H1 has nothing to do with whether or not you properly maintained your F1 status, then yes, you do still get the 60-day grace period from the denial date. But if they determine that you violated your F1 status, there is no grace period.
Will it help to go out of the country and come back to visit any issue with the day one CP2 history? Yeah, assuming that if you are in a different visa status like H-1B, H-4, but then we are at the same time not recommend people to travel to get the stamping though. So that's a risk there too when you're going for stamping. As you know, the Trump administration is not a favorable person to give the stampings to the people. So definitely, if you already change the status in United States and you think so that you're going for stamping to reset, I would definitely avoid that right now. Question from uh, Spartrash Chakravarti. I'm sorry, I can't pronounce it. It's going to be tough for Emily to pronounce these names. She does a very good job than me. What documents we suggest to carry when domestic aid travel for H-1B, other than driving license and real ID? You can, I mean, you can just keep a copy of the H-1B approval with you, though. I don't see a need for you to carry the original H-1B approval. There are a lot of calls that we received. Oh, people are getting thrown out of the country. Have you got any calls, Emily? I mean, there are so many ICE raids that are going on the TV. Have you got any call from any of your clients saying that they got suffered? No,
Nope, not
no,
a
we did
one.
not. Not one, not a single call, not a single call. And you can see the postings. Now, of course, people are panicked. People are calling because they're panicked. Did they really got did they really got checked and everything? No, we didn't see any of those people. The only time we want you to carry the original documents, especially when you are going very near to the border, I would use specifically when you go to South Padre Island or Corpus Christi. These are the border towns. There are some checkposts when you come back into the United States, not in the United States, when you come back from there, some South Padre Island, all those things. There are some checkposts there. But in general, like for example, if you go to San Diego City, but not very near to the border, I don't see any problem for you to carry the passport or original H-1B approval.
Swati says, my 12-year-old child's I-94 is not available in the CBP portal. This is needed for the I-539A document as part of my H-1 transfer. What should be my action? Well, first, just, there are a lot of names that, there's multiple names within the name, and some of them are in the last name, some of them are in the given name. So it may just be a combination of how the names appear, and you may need to change how you're typing that in. You can look in the machine readable portion of the passport, kind of down at the bottom, to verify the order of the names and which box to put them in. So try that first and just try different combinations. If it's still not popping up, you're going to have to contact deferred inspection from CBP. Hopefully you are in a location where where your deferred inspection CBP has an email address, because then you can just email them, let them know, provide the child's passport, plane itinerary, ticket details, and they'll be able to generate the I-94 if it's not there. Otherwise, you may have to go in person if they don't have the email address, which can be quite a hassle and deal with some rude people, but it's possible.
Uh, Prasad has a question that police warning, how does it affect the H-1B transfer extension? If this warning is for a speeding ticket or so, I mean, you're fine. Absolutely, you're fine. I don't see any problem whatsoever at all for you in any of the immigration things. If it's something very major, though, I definitely want you to discuss with an immigration lawyer. Satish has this question. His spouse has started a company while AO is pending. Amazon, and his spouse is the dependent based on the reading that I can do. And can he look for jobs similar to what he was doing on the spouse company? Technically, self-employment is absolutely allowed in the adjustment of status EAD, even for the primary applicant. However, there are some conditions that you need to be met. We want you to be very careful when you go for the interview. So definitely consulting an immigration lawyer, what conditions need to be met. We want the payroll to run. We want to have a documentation you're working in the similar job. Those are the things that you need to take care. But legally allowed, there is a memo that USCIS has issued, and that clearly says that self-employment is allowed on the adjustment of status EAD if it in the similar profession. Anything else?
All right, well, I think we are out of time for today. Thanks everyone for joining us. If we didn't get to your question, we do have a daily conference call that's free on Zoom that you could join to have your question answered there by any of our attorneys. Or you can set up a consultation with us or any of our other attorneys at Reddy Neumann Brown by going to rnlawgroup.com. There's a button to click for a consultation, and you'll be able to see our schedules, provide notes, and upload any documents that are relevant so we can make the most of your 30-minute consultation.